more than 6 years of experience in litigation, especially in field of taxation laws, constitutional real estate regulatory authority, arbitrational tribunals, debt recovery, civil and criminal laws. He has standing at the High Court, tax tribunals, real estate tribunals, arbitral tribunals, and district courts. He handles matters of the automobile, apparel, food, infrastructure, and real estate and banking finance industries. He now works as the associate partner with the law firm 𝗿𝗍𝗰𝗲𝗀𝗍 partner. The second speaker for today's webinar, we have today with us Mr. Apurv Jain. He graduated from National Law University, Odisha with specialization in corporate laws. Based out in Bhopal, he possesses more than 5 years of experience in litigation, especially in field of real estate laws, environmental laws, family laws, civil and criminal laws. He has standing at the High Court, Real Estate Tribunal, Arbitral Tribunal, and the Supreme Court. He has handled matters related to property, infrastructure, real estate sectors. He is also designated as a RERA expert by leading newspapers. Now he is working as senior associate with the law firm 𝗿𝗍𝗰𝗲𝗀𝗍 partners. With that, I would kindly welcome our expert to take the dice, and let us just get started with the session. Thank you so much.
Thank you, Akshay, and I would like to thank all the attendees. A warm and very good evening to everyone. First of all, I would like to thank LawSikho for organizing this this webinar on a very crucial topic, that is real estate regulatory authority, and we will be discussing just a minute. Yeah. So we will be discussing about the RERA, its procedure and practice. We will be discussing in detail how RERA acts as an regulator, as well as how RERA acts as an adjudicator, because it's under this act, RERA has met both as a regulator to regulate the entire real estate sector, as well as a adjudicator also, because all the disputes which comes between the promoter and allottee, RERA is established a quasi-judicial authority as well to discuss and adjudicate their dispute. So I call upon my colleague Apurv, who will be dealing with the basics of the RERA, and then we will be discussing how it is acting. Now, by this act also, RERA has not only opened the doors for advocates, but also for chartered accountants, company secretary, chartered engineers, and valuers, and all other organizations which are dealing in land-related issues like TSR bodies and all. So, Apurv, to take up the session for basics.
Good evening, everyone. First and foremost, thank you, Akshay, for the wonderful introduction, as well as my kind gestures to LawSikho. Moving forward with the first slide, we have here the expectations versus reality. So, why before moving with the practice area, we would actually stipulate why this particular law was needed in the first picture. As you all know, the expectation, a builder, a promoter of a particular project, he states that this is your particular property, you're going to visit this particular property, that would be your property location, you will have lavish, lush green gardens, you will have a pool side, you will have actual view. Now, moving forward with the reality is something very much different. You see, I know it's a bit of a hefty work here, making expectation into reality something very different, but this is the actual picture, why RERA law was called for. Moving forward, we all know that from the inception of the execution of the law in the year 2016, it was actually imposed, and right now for the 4th year it passed. So many recent developments have been made. And moving forward, we all know that when it comes to real estate sector, I think real estate sector is said to be one of the major employment level sector. It provides employment to everyone, I believe, like everyone, a number of people, and so many people are attached to it. So when RERA was introduced, the aspect was not limited to a lawyer only. The aspect was also to introduce a correlation with a CA, a correlation with an engineer, a correlation with a valuer, and as well as the advocate. All of them should be clubbed together to bring into a platform to actually work for the public, to provide them promotion of the real estate sector. So moving forward, Prateek, handing over to you.
Yeah, so today we will be dealing with what are the salient feature of this RERA Act. The name of the act is Real Estate Regulation and Development Act. So we will be discussing about the salient feature and overall what are the provisions under the RERA Act, how RERA Act is a regulator, what are the rights and liabilities of promoter as well as the allottee, how RERA Act is an adjudicator, what are the punitive measures which is given under the RERA law, what are the correlation between the RERA law and others law, about like if the conflict between RERA and 𝗥𝗘𝗥𝗔, which law prevail over which law, and then recent few case law we will be discussing in and its implications. So let's start with if we talk about any act, the preamble of that act is very important. So let us see what this preamble says. It says that it is an act to establish a real estate regulatory authority for regulation and promotion of the real estate sector. The point which is to be noted here is that it is not to diminish or to curb the intention behind introduction of this act to promote the real estate sector. That is by bringing the transparency between the allottee and the promoter, bringing the every document should be public document, whether a project should be developed on a defect-free title. So this is and also they have provided a rated agency as well. Second, to ensure sale of plots, apartment or building, as the case may be, or sale of real estate project in efficient and transparent manner. As we have said, that everything comes under the RERA after the implications after the implementation of this act. So it is not limited to plot, apartment, building, but it is also extended to commercial property as well. So, and to protect the interest of customers in the real estate sector. So of course, like in earlier, there were so many whims and fantasies which is imposed by the builder to they draft an agreement in such a way there is no completion date is given. So RERA has regularized and standardized everything. Now it is acting as in the interest of consumer, in the interest of allottees, and their right should be at supremacy. Moving on, and to establish an adjudication mechanism for speedy dispute resolution, and also to establish appellate tribunal to hear appeals from the decision, directions, and orders of the real estate regulatory authority. So this is the preamble of this act. So the structure of the RERA is that so it has 10 chapters. It has 10 chapters, wherein first chapter talks about the preliminary and its definition. The definition is so exhaustive that it defines allottee, it defines promoters, it defines corporate area, floor ratio area, it defines who are the real estate agents, what are the unit means. So it is a very exhaustive definition which is provided under the RERA Act. Then registration of projects and agents, it range under this chapter 2, that how a project should be registered, what are the implication if a project is not registered. Okay, and if an application for registration is rejected, then in what manner it should be rejected. So it deals under chapter 2. Chapter 3 talks about what are the functions, or we can say what are the duties imposed on the promoters. Then right and duties of the allottees, it is under section 19. Then chapter 5 talks about establishment of real estate regulatory authority. And then Central Advisory Council, time to time RERA also gives advisory to say government and central government also to what are the upcoming and what are the shortfall under the RERA Act, so they can advise to government as well. The RERA chapter 7 talks about establishment of real estate appellate authority, and then offences, penalties, and adjudication mechanism, and then there are the miscellaneous provisions as well. So overall, we can say that RERA is the regulator of the real estate sector. It promotes the real estate sector. It is by which it is bringing the transparency in the industry. Like it is not earlier, it was like the real estate sector is a very gray sector. Nobody wants to go, and everybody is very and they used to think that promoter will make misuse of their money. Okay, so this is also by the mechanism of transparency. It is bringing the transparency in the real estate sector. It is also an adjudicator of the disputes, which we will be dealing in detail as well. then it protects the interest of allottee as well as the promoters. So it is not only limited to the interest of the allottees or only limited, but interest of promoters are also protected under this act. Then it is a single window mechanism. Like you need not to rush to each and every department. You can see every document which is related to your property, what is the status of your project on your and the website of the RERA. So this is a very good thing, which is very appreciable, which is brought under this act. And then schedule fund utilization. This is very important. Like earlier, what used to happen that a promoter used to raise money in the name of project A, and then instead of developing project A, they divest the fund into project B, and then on the name of project B, he again raises the fund and then transfer the whole fund to project C. Now neither the project A is completed, now neither the project B is completed, neither the project C is completed, and promoters gets bankrupt. So in this act, there is a scheduled fund utilization also given, which is very important for a chartered accountant as well, because the CA report is also be submitted to how to utilize their fund and all. And then digitalization, everything is on digitization. It is not that you have to go to and personally visit to the RERA office and see what are the documents he has submitted. No, it's everything is on online. And then regular checkups. It is not like once your project is registered, it is gone. You will be called after 5 years whether the project is developed or not. In fact, you have to give quarterly checkups, like we have developed this much project, we have sold this much of units in our project. So this is how regular, by way of regular checkups, you can see the progress of a project, whether it is actually being developed or not. So the salient features are that it is against the transparency is brought into account, accountability is also imposed on the promoters as well. Then there are so many assimilated information but after this RERA, every information is on the website. You can see, you can do it your own. Yes, like a 𝗘𝗿𝗰𝗀𝗀𝗀, you can see and you can judge the project whether you should invest it or not. Okay, then by this act, the confidence in the allottees is also increased. Like if you go and you see this project is registered with RERA, then allottee also feels like my money is not going anywhere. So this is also brought the confidence to the allottees as well. And then again, the trust deficit between promoters and all buyers are also it's reduced. So because of this RERA Act, again, single window system approval is there. And then there is a time-bound manner complaint disposal mechanism is also given. Like it is not like civil courts that you file a complaint, it will remain pending since 3 years or 4 years. It is not like that. Complaint is to be adjudicated within 3 or 4 months. And then buyers are also now more enthusiastic to invest into this sector. And then it has the exclusive jurisdiction over any other law for the time being. This is very important. And so far as the Consumer Act is concerned, when we will be discussing about the RERA versus other law, we will be discussing that how it will be factored in the RERA Act. Moving further, now I would like to hand over the Apurv. He will be discussing about how RERA is acting as a regulator.
So about the practice area, how RERA acts as a regulator. Now RERA applies to these entities. One, the real estate project. The second being the promoter, the allottees, and the agents. Basically, real estate project and the promoter are one entity because the promoter is the developer of that particular project. Allottees are the concerned buyers of that particular project who actually go and purchase the property. And agents are actually the intermediary, the middleman between both the promoter and the allottees. And when it comes to RERA actually, when it comes to this particular agent, RERA actually brought this a new concept of registering the agents also, so that the liability could be imposed upon those agents who are providing wrong information either to the allottees or the promoters. Moving next.
I think I recall one incident when most of the persons must have faced when they approach to some agents or broker. They show a property in such a way that it will be, the price will be increased, everyone is investing in this project and everything is very good. And when you actually go and see the property and whatever is then builder says that it is not promised by me, it is promised by the broker. But by this act, agent is also held liable if they make any misinformation or fancy advertisement to the allottee. So this is also an aspect.
Moving forward. Now, the major portion, one of the major areas when it comes to RERA, being the project registration. First and foremost, the projects have been identified into two groups. One being the ongoing, second being the new. Section 3 of the RERA Act states that if a project hasn't received the completion certificate or the occupancy certificate on the commencement of this act, that project would be identified as an ongoing project.
I think audio is not
Just I believe there's some network issue here.
Great. So, as we were speaking about, project has been demarcated into two aspects, being the ongoing, being the new. Ongoing being the projects who haven't received the completion certificate / occupancy certificate on the commencement of this act. Second being the new projects. So the new projects are those projects which actually came into which were actually introduced after the law was imposed. So now coming to the practice area, how do we apply for a project registration? First, you apply to the RERA via an online application. All the promoters needs to apply at how we'll see the documents which are needed for, but they have to apply online only since it is a new law. So they have adopted a proper mechanism, that is online application only. They don't go for hard copies at all until unless some necessary documents such as affidavits or any necessary document has been required for. Going forward, submission of documents. If we kindly look forward to the documents. So these are documents which are actually required for the registration. First and foremost, it's not like that every real estate project is supposed to get registered with RERA. Those projects which have minimum area, as in if they exceed the 500 square meter area, then only they are supposed to be registered with RERA. The second being, if they are proposing any sort of constructive unit, they need at least 8 units, minimum 8 units to be constructed. If it is beyond 8 units, then it will be registered under RERA. Second being the promoter details. As we all know that every promoter couldn't be just a single person. It could be an entity, it could be a firm, it could be a company. So they need to provide each and every details as such. Next being the land details. Now we all see that one of the major gray areas when it comes to land ownership is with regard to a dispute between the developer or the owner of that particular property. So that's why RERA asks for the ownership. If it's a joint venture, as in developer is developing the project and the owner is a separate person. So RERA asks for a joint venture. RERA asks for a joint venture. RERA asks that is there any sort of agreement between the landowner or the developer. Moving forward, compliances. Now these are the statutory requirements by RERA law. If we could find them enumerated in the RERA law itself. First being the bank account. So RERA asks for a designated bank account, as in they would require you to get a designated bank account for that particular project only. They would require you to make a bank account. And the bank account money should be only utilized for the purpose of construction and development of that particular project. Next being the balance sheet, the tax returns of that particular entity, being the partnership firm or the company. Next comes the CA certificate. Now CA certificate should be provided by a designated CA who will provide you the details of the cost of the construction, the estimated cost of the construction of that particular project. So let's assume for a minute that this particular building requires around 500 crore to be developed. The CA will provide each and every minute details, as in how much money should be utilized for the construction of this particular structure, how much money should be used when it comes to the amenities, and every minute details should be provided. Next being the engineer certificate. Now the engineer provides as in the time period, as in the requirement as to when the project will be completed. We all know one of the major reasons why RERA law was called for was that the projects were actually not delivered on time. I believe that we are well aware of the 𝗲𝗶𝗰 judgment, which was actually declared by the Supreme Court itself. One of the major flaws in that particular project was the project were promised long back, but no delivery was given to the concerned allottees. And that's why Supreme Court interfered and made such and such order. So actually in that particular order itself, the Supreme Court has enumerated the part of a RERA Act. The part RERA must actually entertain and make force with regard to the benefit of the real estate sector. Moving forward, the permissions. Now as we all know that it's not limited that RERA will provide the permission with regard to the construction of any property. You need the permission of the town and country planning to actually make the layout map of that particular project. You need the development permission from the municipal corporation. It's obviously depends upon state to state. So every permission when it comes to a real estate project which is required for a construction of a project should be provided to RERA, that they have got every single permission for a particular project. Moving next, the clearance. You need to provide the clearance as to there is no sort of encumbrance with regard to that project. You need to provide details as to the pollution control board if it's required. If it's required that you need environmental clearance also, you need to provide those details also. Coming next, the project details. You need to provide the exact area. See, when RERA asks for the area details, it's not like you just put the information on your whims and fancies. You need to provide it as it is. It has been portrayed by your engineer or the layout map. Reason being, the concerned allottee must be provided the exact area he has promised and the money he has paid for. The area with regard to the plot, the apartment, the duplex, anything, you need to put the exact details. You need to provide the details of the brochure as well as prospectus, because we all see that in the brochure, the picture looks so good, so extravaganza that you are actually very much mesmerized by the actual picture of that brochure only. But in reality, it's something very much different. So RERA obviously asks for the brochure, the prospectus, whatever project has proposed, so that they can look upon the specification of that particular project and let you know that these are the requirements. Moving forward, legal documents. Now, RERA has done a wonderful part in this juncture. They have actually made their own sale agreement, so that as we all know that what the builder used to do, builder used to provide their own sale agreements with their own terms and conditions. Now, what RERAs are that if you are registering with us, you need to provide a draft agreement as per our requirements. You can't make the terms and condition on your own. You need to provide the details as to that when you are going to provide the project property, when you are going to deliver the property, and what level, what all facilities will be provided, and what all amenities will be required. Also, the allotment letter, everything. RERA has actually made it a clear picture that you will work, but on our conditions. Moving forward, the declaration with regard to the representation and warranties of the builder that they are going to work in compliance with the RERA law only. Apart from the documents, RERA also asks for development work plan as to on what particular date you are going to complete this particular premises, this amenity with regard to that particular project, what all project specification you need to provide. There's so many junctures at where RERA is going to ask the builder that these all details are required for the project registration. Moving forward. Prateek, can we go back? Sure. Now, after submission of these documents, RERA move with the payment of fee. Now, RERA has on its own provided the payment of fee on the basis of two different aspects. When it
I think we are experiencing a bit of a network issue. Please stay here. I hope this is going to get good soon. There seems to be a little of network issue.
Hello.
are we audible? Akshay?
Yes, we can see you. We can see you.
Akshay?
Yes, we can see you. You're audible as well.
Hold on.
Are you audible?
Yes, we can hear you.
Yeah. Great. Moving forward. So we requirement the payment of fee. As I was saying before, with regard to that particular, if a plotting area, it's it's calculated on the basis of FAR. If it's constructed, it's calculated on the basis of carpet area. Now, when the documents have been provided, now the RERA, what it does, it vets the document. It cross-check that all the documents are up to date and very sincere when it comes to that particular project. Moving next. Now, if they find that there are certain objections which should be raised when it comes to the registration of the project, they put forward, they asked the promoter to come down to their office and ask them that kindly clear these objections. They provide them with an opportunity of being heard. And after the opportunity of being heard, they provide them with the registration, or either they register it or they reject it.
So I would like to add here, most of the chartered accountants, company secretaries, and advocates are working here. Their requirements are also here, because most of the time RERA simply puts an objection that your land is not defect free, or we find these objections, and most of the time promoters unable to defend their case, and due to which their registration got rejected. And also consequential effects also there, like you can't construct the project over any project over this property. That actually harms the very nature of their property. Like if I want to construct anything on my property, although you are not granting a registration, but still I can develop it in my own way. Although I cannot call money from the public that you come and you register a project, but most of the time this the role of advocate and chartered accountant, if in their individual capacity, also very important in registration project as well. And there are a lot of documents and are there, so one can practice in this area as well.
Now moving forward with the real estate agent. So real estate agent is any person, as I was speaking before, including property dealers, brokers, middlemen. Prateek. Negotiates or acts on behalf of either party. See, basically, as we all know that why real estate agent is asked to be a part of this act so far, because they actually negotiates or acts on behalf of either party, and they actually gets remuneration. So it's limited to the real estate project which are registered only. As in, if you read the definition of real estate agents for registration, they need to work as a real estate registered agents only when they are dealing with a real estate project which are registered with RERA. They work with regard to a sale, transfer of plot, building, or apartment. They receive the remuneration of fees or any service for his service, and that's why the registration is required. Now moving forward to the real estate registration. First, it's simple. It's not that hefty when it comes to a particular project, but the real estate agents, the details, it's either an individual, a firm, or a company. Then they need to provide their personal details. They need to provide the PAN card details, the income tax return, authenticated copy of address proof of place of business, and the fees is very much clear from the very act itself. Then when it comes to an individual, the real estate agent is supposed to provide a minimum fee of 10,000, and in case it's other than an individual, either it's a firm, either it's a company, so or into a business, it's the fee is 50,000. So
I think this is very important for this online property searches engine. There are so many companies who are dealing in this aspect only.
Yeah,
so
like Magic Bricks.
We cannot name any individual, but there are so many websites, you must be knowing, they are working in this area. So this real estate agent, if they are falling under the definition of real estate agent, then they have to get registered themselves with RERA. So therefore this is very important. So allotee.
Last but not the least, the allotee. So an allotee, a buyer could be any person. It's not limited that he could be a separate third person, but he could be any person. Person being Hindu undivided family, an entity, anyone. Purchases plot, apartment, or building in any real estate project, I was telling before. Does not include rented premises. Yeah, this is one of the major portion when it comes to being an allotee. Now the question arises that whether leasehold property, as we all know that in different regions, the property has been actually owned by the government and they provide the property on lease to that particular builder, and the builder sublease that particular property to this particular allottee. So whether those should be included in this particular rented premises also. In this regard, the Bombay High Court has stated that when it comes to long-term leases, those people who actually enter into an agreement with the long-term leases, they would be defined under definition of allottee under the RERA Act. So now we all know that when it comes to long-term leases, you can be an allottee under the RERA Act. They have a right of possession. Obviously, ultimately, it's your right over that dwelling house or that particular property. Regulation under RERA. So it's not limited. See, as we were speaking before, RERA is a consumer-oriented law, but it does not actually bars the right of the builders also. It's for the promotion. By the very preamble, if we read, it's for the promotion of real estate sector. So in case an allottee or a buyer makes default, a builder has a right to approach RERA and ask them to provide them that whatever defaults have been made by the allottee or that buyer should be reimbursed to that particular builder. And that's why coming next, it's maintaining rights and liabilities. So if a allottee has been provided a particular property in a particular project, he should abide by all the rules and regulations of that particular society. He should form a society. He should work under the provisions of whatever terms and conditions have been stipulated in the agreement. It's not like he can bypass the agreement also. He should work. See, the purpose being that both builder and the allottee should work hand in hand with regard to that particular project. Now, moving forward, Prateek, handing over to you.
Yeah. So RERA also provides rights and liabilities of a promoter as well as allottee, and here is where the cause of action arises. So like there is a very principle of a law that 𝗿𝗿𝗰 remedy. If you don't have any right, you don't have any remedy. Or if you have remedy, then you have right also. So first of all, what are the entitlements which are given to a allottee, which are a very genuine entitlement every allottee should need? So first of all, allottee has right to obtain information, what are the sanctions plans, layout plan specification, and if a building is not constructed as per the specification or the layout plans, they can easily go to RERA and file a case against a promoter. What are the stage-wise schedule and completion of the projects? Because this is the very general ground for allottees to go and approach the RERA, that they have not handed over the possession in the given time. So therefore, allottee is entitled to know what are the stage-wise plan of the schedule, and if promoter fails to complete the project in that time, then allottee can go and file a case before RERA. Then the claim of the possession of apartment, including the common areas. Now, what happens if in a building there are so many units like flats, penthouse, and then shops, there are showrooms, etc. But what about the common properties, which are the terrace and the garden, the swimming pool, and all these things? So RERA provides that after the completion of the project, all the common areas should be handed over to the association of the allottee. This is the very important point, and most of the builders, they fail to do it. So this is also entitlement to allottee. Claim refund of amount with interest in case revocation of RERA of the registration of the promoter. So suppose a promoter fails to develop a project in a given time, and even after if his time period is extended, then what RERA does, RERA revokes his registration and handed over to the government to complete this project. And the first right to refusal will be with the allottee or association of the allottee, that okay, we want to get it complete from X authority or Y authority. So, and even if the project is developed in that way, then allottee is entitled to get refund of the amount from the defaulter promoter. So promoter is not like that, okay, my registration is revoked and I'm not able to give you any money. So this is not the case. The claim of refund of amount paid along with interest in case failure to provide timely possession. This is the compensation which is provided, and that is with the interest. So section 19 and section 18 clearly talks about that allottee will be given two choices. First choice, whether you want to remain in the project or you want to quit the project. If you want to remain in the project, then you will be entitled to get interest and compensation of each month till the time the promoters hand over the project. And if he wants to opt out from the project, then he will be entitled to receive principal amount as well as the interest amount at the interest rate which is prescribed by the State Bank of India or the nationalized bank. And like my Apurva said, that the agreement prescribes the sale agreement, which is also standardized. So the rate which is given under the agreement, that interest rate will be allotted to the allottee. And claim all the original document related to apartment and common areas. This is also an entitlement. Then like there is no right without liabilities. So there are also liabilities which is also cast upon the allottees. That first of all, he has to make payment in the manner and in the time specified in the sale agreement. If he delays any payment, then he is liable to pay interest also. So these are the areas where promoter can go to RERA and seek relief that, okay, my payment has been delayed, so I need the interest. Or participation in the formation of association of housing society. This is also a liability, like promoter says, so I am ready to hand over the property or the common areas to allottee of the association, but promoters, allottees are not coming to form the association. So it is liability of the allottee to come and make their every effort to form the association, and then take possession within 2 months from the issue of the occupancy certificate. So this happened in those cases where people just invest their money to real estate project, and they make the payment, but they don't occupy they don't take the possession. So in that sense, what happens, promoter has to maintain the property, and since nobody takes the possession of the property, so in that case also promoter can go to RERA and say that my property is ready, but they are not taking the possession. Participation towards the registration or conveyance deed. This is also happens. Sometimes allottee himself doesn't turn up to at the time of registration. And liable to pay maintenance charges, municipal charges as may be agreed. So it is the liability of the allottee that when property is handed over to the allottee, then he is liable to pay all the property charges, maintenance charges, voided charges that has to be given by the allottee. Then what are the functions of the promoter? First of all, he has to create a web page and provide all the information about the project on the website of the RERA as well as on his website if he has. And that information should not be misinformed or false information. Second thing, provide RERA registration number on all the advertisement, and all the advertisement should be pre-approved by the RERA. He cannot publish any advertisement without the approval of the RERA. And if he publish, then there is penalty provisions are also there. To give information to the allottee about sanction plan, stage-wise scheduled plan, etc. It is also given at the time of registration only. To provide quarterly reports of the development of projects. And if he fails to do it, the RERA has power to first suspend his registration, and even if promoter does not turn up, then he can revoke his RERA can revoke the registration as well. And then quarterly up-to-date list of approval taken to be taken. So here comes the role of structural engineers as well as the chartered accountant. So like I've said, there is a scheduled fund utilization of is also given under the RERA, that suppose a person has allottees has been given funds to the builder. So he cannot take away any amount from that designated bank account. He has to submit a CA report to the RERA, and then only he can transfer the funds for the purpose of development of the project. So the fund is also secured. To make project information including cost of the project to public. So this is a very transparent manner, transparency which has been brought by the RERA.
I would like to add something here.
Yeah.
Speaking of the quarterly submission so far, it's not limited that the quarterly submission just be on just mere papers. Actually, when it comes to the quarterly submissions, the RERA asks for the CA report as well as the engineer report, asking them to provide the exact details as to what is the up-to-date status of that particular project. The next thing they ask for are the photographs to cross-check that the project is actually working on its scheduled stage-wise working manner also. So and also they cross check. It's not limited that they ask for the details, they provide it. They also cross check that whether this project is up to date or not. If they find that this project is not working on its remarks, they send them a notice asking that since your stage schedule is that you are supposed to get your project completed by the year 2021, but by the prospects and by looking at the photographs and by looking at the report states that this particular property project is still not going to complete on its deadline. You need to provide us with the reason why you are delaying this particular project. So this quarterly report submission is one of the major prospects which actually could help that why this particular project is going to complete on this particular time. Again, there are extension. Obviously, there are exceptions that they could actually go for extension of that particular project. And by this particular COVID, as you all know, COVID and lockdown, the government has actually provided an extension of 6 months to every project whose delivery date was after March 2020. But still, they need to provide details of each and every status of that project. Prateek, handing it to you.
And also it also opens the forum for litigations as well, because they cannot impose a penalty or they cannot simply ask for information. If they ask for information, there is a separate miscellaneous case is registered against the promoter, and then they impose a penalty or proceed in accordance with that. So there are the duties as well to compliance with the RERA provision. This is the first and foremost duty, to build the project without structural defect. So what happens in a structural defects? Suppose a project is developed, but the developed project is of so low quality that it may fall, or there are so many seepage and all. So a allottee can go and file a lodge a complaint against the promoter, seeking that he has used the low quality of material, or he has used that the building is built in a structural defect. And RERA has, in so many cases, RERA has ordered to remove or fix these such structural defects. And then responsible to obtain completion certificate from the relevant authority. It is also duty of the promoter. And in most of the cases, in the local laws, because that occupancy and completion certificate is given by the local authorities or municipal corporation or panchayat, and so there are the deemed provision as well. If you apply it and they don't give you completion certificate, then it will be in most of the municipal acts, it is deemed that you have been given a completion certificate. And then to provide essential services on reasonable charges. It is not like that they have opened a clubhouse, but they are charging unreasonably and with the very high price. So all the essential services like water, electricity, swimming pool and all, so they have to provide it in a very reasonable charges. And then to form a housing society, the first liability is cost upon the promoter, to that if in a project there are more than 50% of the allottees or the projects are booked, then they have to form a housing society and hand over the project to the housing society. And then to maintain the common areas as well. So if it is not handed over the association, then it is duty of promoter that he has to maintain the common areas, and of course he can charge maintenance charges as well.
I would like to add something here.
And similar entitlement duties are also cast upon the real estate agents as well.
So as Prateek was speaking about the structural defect, so section 14.3 actually stipulates a timesheet as to how structural defects could be cured. RERA doesn't let you provide the delivery of the property. They also maintain that the property should be maintained for a minimum period of 5 years from the date of possession. So after taking possession, if we find that this property, something like any sort of like the pillars, the seepage issue, the water is dripping, there's a cracks in the pillars and everything, that is actually a structural defect. And various other states like Tamil Nadu, Andhra Pradesh have actually stipulated definition of okay, I believe we need to speak a little slowly here. But again, speaking of this structural defect, if we find that there is a seepage with regard to that particular property, and you can find cracks on the pillar, you can actually call up the builder and ask them to cure that structural defect. So from the date of possession till 5 years, you have the right to approach builder at any cost and ask them to remove that structural defect. Second part being uh, responsible to obtain the completion certificate from the relevant authority. So a completion certificate, as stated before under section 3, completion certificate declares that this particular project is complete in every aspect, be it internal or external specification, be it any sort of amenities, all have been completed. So one of the major areas of promoter to cover up its project is to get a completion certificate. If he doesn't receive the completion certificate, he has to provide every details, as in he has to regularly comply with the provision of RERA law. So somehow, in one way or another, actually after the commission of this act, promoters are actually looking forward to complete their project on time so that they can actually get out from under the compliance of RERA law. So it actually helps in both ways. Prateek, handing over to you.
So now we will be discussing how this adjudicating mechanism is governed under the RERA. So how RERA act as an adjudicator. So moving forward. So first of all, RERA applies to where is the jurisdiction. For every contravention in the RERA law, RERA has jurisdiction to adjudicate it. No other authority can adjudicate this issue. Then any aggrieved person, this is governed under section 31. It is not only limited to the allottee or promoter, real estate agent. Even a neighbor or any other person, affected party, can go and file a complaint before RERA that this project is not constructed as per the sanction plan, and because everything is public. Now RERA has also power to take suo motu action if it is brought to the knowledge of RERA that something is not going as per RERA law, that they can take a suo motu action as well under section 35. Then civil court has no jurisdiction to entertain any disputes where RERA has jurisdiction. So this is also given under the RERA. And then so there were the issue earlier, consumer allottee used to go to consumer forum. Now they have given the option, either they can continue to with the consumer forum or they can file a complaint. They can withdraw their complaint from there, from the consumer forum, and they can file the case before RERA. So this is the only option given under the RERA. So allottee can contest the case before consumer forum as well as in RERA, but one at a time. It is not like he can file a consumer case and then also file a RERA case as well. So complaint is to be filed in Form A before the RERA, Real Estate Regulatory Authority. As we have said that it is a quasi-judicial authority. Every disputes concerning to the rights and duties of the allottee, rights and duties of the promoters, whether is there any promoter versus RERA dispute, it has to be adjudicated by the RERA. Now RERA, after taking a cognizance of the matter, they call the other party, the reply is filed, but it is not as such they are not bound by the court of civil procedure. So it is not like that every document has to be exhibited and statements are taken. It's a simple mechanism. You file a complaint, other party is called, and then they try to mediate or conciliate between the parties. If it fails, then they decide the compensation or the whatever it is, compensation or interest, and then the case is forwarded to the adjudicating authority, who decides the compensation amount. So on the merit, whether the compensation or interest will be given or not, it is to be decided by the RERA, but the amount of compensation should be calculated by the adjudicating authority. So this is the law, and it is the authority which is subordinate to RERA authority. Then if a person is not satisfied with the RERA order, he can file a appeal within 60 days from the Real Estate Appellate Authority. It is headed by a retired High Court judge, and it has 2 members. One is a judicial member, one is a technical member. So he can file a case before RERA, Real Estate Appellate Authority. And if it is not filed, if he is not satisfied with the REAT as well, then within 60 days, appeal is to be filed before High Court. And after High Court, the Constitution of India and other CPC provision will be applicable if somebody wants to go to Supreme Court. So this is the staircases of the RERA adjudication mechanism. Now, what are the powers which are conferred to the RERA? So first of all, it can impose the penalty and interest and also recovery also. So since RERA is the central act, but the power to make rules is with the state government. So every state government has their own rules and their own procedures. So there may be some variations. Okay. So like interest rate and penalty rates and recovery mechanism, like since we are practicing Madhya Pradesh, so they have appointed a recovery officer as well, which is of the level of Tehsildar. So, but we are not sure whether this provision has been brought into the other states as well. Also, they have power to revoke registration of the real estate project as well as real estate agents as well. It is power given under Section 8, and Supreme Court in the case of 𝗲𝗷𝗊, they have revoked the registration of 𝗲𝗷𝗊 group as well. So they have power to call for information, conduct investigation also, like if they need that some crucial information is required to adjudicate the dispute from the public authorities or any other party, then they can call for information as well. And conduct investigation as well, like they can appoint their panel architect and their panel engineer as well to go and do a survey and conduct investigation whether the project is actually completed or not, whether the project is actually constructed as per the sanction plan or not. So they have power to do investigation also. They have also power to issue interim orders and interim directions as well, like stay applications. And then enforcement of its directives. So every order which is passed by the RERA authority will be executed in the same manner as if it is a decree of civil code. So these are the powers conferred to RERA under the RERA Act 2016. Now let's talk about the RERA versus other laws. So first of all, RERA versus insolvency and bankruptcy laws. So in 2019, central government has come up with the act that all the real estate allottees, they are also an financial creditor under the insolvency and bankruptcy code. Now they have put up a limit that only 100 allottees can go and file a case before NCLT. And then now that act, that regulation, that amendment has been struck down by Supreme Court. So now in 𝗲𝗷𝗊 case, it has been held that RERA will supersede the provisions of the bankruptcy insolvency bankruptcy code when it comes to allottees. Then RERA versus consumer forums, like I have just stated, that the allottees will be given an option that if they want to continue their case with the consumer forum, they can proceed with it. And if they want to transfer their case to the RERA authority, then they can do that also. RERA versus civil courts. RERA, by virtue of RERA Act, civil courts had their jurisdiction has been barred. So every dispute concerning to the property allottee or even the land related document, that has to be go to RERA only. Then RERA versus criminal courts. Since criminal courts have separate jurisdiction, RERA cannot do anything which is mentioned under the IPC. Like if any crime has been committed, then it has to be tried by the magistrate. RERA has no power to adjudicate it. They can mention in their order that some fraud has been taken place, but whether the fraud has been taken place or not, that has to be decided by the concerned judicial magistrate. And RERA versus special and other special enactments, so like 𝗥𝗍𝒄𝗍 and all. But when it comes to the RERA, the allottees, the RERA will anyway supersede any other enactment which has come into the force.
I'd like to add here something.
Yeah.
If I may. Speaking of first and foremost with the RERA versus insolvency and bankruptcy code, latestly 𝗥𝗘𝗥𝗔 made an order with regard to a person in whose favor a decree was made by RERA, and rather than approaching RERA under execution under Section 40, he approached the NCLT under Section 7. NCLT stated that yes, you have a decree, but by virtue of this particular RERA decree, you can actually go for the execution under RERA law only, but you cannot approach NCLT for under the insolvency and bankruptcy code. Apart from that, when it comes to RERA and versus special enactments, as we all know that when it comes to any agreement, obviously in an agreement, an arbitration clause is always there. Now, the question being whether RERA law will supersede that arbitration clause also. In most of the cases, it has been stated that RERA law is a special law.
and special law always supersedes over in general law. So when it comes to arbitration, and there's a tussle between arbitration and RERA law will supersede. So obviously when it comes to case and you the builder says no, there's an arbitration clause, no, you obviously you can go to the RERA court at all costs. Now the punitive measures, as we all know that since there have been so many offenses, there has been penalty prescribed in the. So when it comes to advertisement, market or selling,
In the time we should
Sure.
some time for question and answer.
Sure, no issue. So as I'll just
So
make
these
it
are-
make it
there
swift
are
in a
the-
swift manner. You can also always see that you cannot advertise if failure to make an application. You have to make penalty with regard to 5% of the estimated cost of the real estate project, and you cannot advertise, market, sell. If you do so, you will be penalized in such and such manner. And there are other provisions also. Moving forward, now when it comes to the imprisonment order, Real Estate Appellate Tribunal has the power to actually make a order of imprisonment against the builder if the builder does not comply with the orders of Appellate Tribunal. The powers has been limited to the Appellate Tribunal only, but RERA then has it. Obviously, the state's provision can actually make the amendment with regard to their own rules and make the changes as such. Moving forward, Prateek. Again, as I was saying, that it's not limited to the % of the estimated cost of the real estate project. And again, last but not least, the allottees. So as I was saying, the allottees was also actually penalized under this act. Prateek, moving forward. There are the implications. Finally, the finance, the cash flow liquidity management. So this is one of the new things which has been brought forward by RERA law. As in when any amount has been provided, like let's assume for a minute that 100 rupees has been provided by the allottee to the builder. So the builder could only keep 30%, and the remaining 70%, here's 70%, 70 rupees is to submit in that bank account. He cannot just there, he could not keep the 100 rupees with him. He has to provide 70 rupees to the bank, and he could only take out the money in accordance to the development of that particular project. So he cannot go beyond that particular provision. Managing project wise in bank account, he has to manage impact on pricing. Obviously, this will mention that what is the amount of that particular project, alternate ways of funding, sourcing equity. So obviously it's not limited that he could obviously go for other like they can mortgage to the bank, or there could be insurance. So there are so many prospects when it comes to financing, which actually is helping when it comes to after the implication of RERA. Moving forward, legal and regulatory, as I believe we have mentioned everything from the very beginning, that how RERA regulates the very prospect of how a land should be made, how a land is proposed, how a project is supposed to be proposed, and how a project is to be made in lieu of the compliances mentioned by the RERA law. So aligning of agreements of sale, deep land due diligence, registration, extension. If a property has been mortgaged to anyone, if any third party comes into picture, so RERA will ask for the non-incumbent certificate that yes, the property hasn't been mortgaged to anyone else. I think if we move. So design, yes, obviously the design being that you need to mention that this is the actual property you are going to get. If I state that this is a bookshelf, that should be the bookshelf. It shouldn't be anything else. Structural defects, as I was speaking before, within the 5 years of possession, if you find any structural defect, the builder is liable to make them right. Moving forward, again, minor with major alteration changes in accordance to the requirements of the allottee. Institutional periodized RERA checks. RERA will actually check for whatever development had been made by the builder. The operations, again, strengthen delivery and management capabilities around execution, monitoring, handover in operation, managing alternate addition, everything. As in, it will operate in such and such manner so that RERA would have a proper check over the development of that particular project. Last, project compliance audits, and coming to marketing, sales, CR, no project advertisement or marketing before registration. So again, keeping a checks over that particular project that you cannot market, you cannot advertise, you can do anything. Yeah.
So there is one point, unlike the other projects, RERA has also provision to provide credit rating system also. So I don't know whether any RERA has implemented it or not, but still there would be rating mechanism as well, that this builder has this ratings out of 5 and 10. Then allotee can easily judge that this whether to invest in his project or not. So this is so we can say that this law has been framed in such a manner that our modern requirement has been addressed. So now, Akshay, I would like, if somebody has any questions, then he can ask any questions.
So we had a first question.
So I can't see the question.
All right. You can take anyone you want. It's in the
Can you
Q&A box.
read it for me? I can't see the question.
All right. If application of registration is rejected, what does it mean for the project and the buyer? Will buyer not be able to work on the project? And is the registration required for starting project or any time after starting the project?
So first of all, no promoter or a real estate project can be developed without taking a prior registration with RERA. If he has not taken any registration, he cannot even take any money from allotee as well. So every allotee who is investing or giving any money to promoter, he should first check whether the project is registered or not. And if it is not registered, that it is advisable to them not to invest in that project, because if it is not registered, then his money would be in great difficulty. But even after he has paid any money and the project is not registered, then also he can file a case before RERA and claim their refund. If I may add to this. Next question.
Next question is,
if I may, I just want to add answer to the last question. I would state that if a project has not been registered and you have invested money in that, so obviously you can approach RERA. Now, when it comes to the practice, it's not that if a project has been registered with RERA, you cannot actually claim money. On the contrary, RERA will ask that particular builder who is developing the project that why haven't you registered yourself with RERA? First and foremost, they will put the restriction over it and ask them first and foremost to get registered with RERA. So one way or the other way around, you will get benefit from both sides, because RERA will ask that particular to get registered, and hence it will be under compliance with the RERA law.
all right. We have 3 or more questions in the Q&A panel, so I'll just say one by one. So next is, in case of delayed possession where the project is not registered, how one should go about to claim refund? Almost 4-5 years are over since the payment was made to the developer. What I heard is that the authority is not giving any relief to buyers, saying out of RERA jurisdiction.
No, so this is not the correct position. Any promoter, since this act has been made with retrospective effect, as in not it is effective from a retrospective date, but it covers all those projects where completion certificate is not given to any builder, then they also falls under the RERA Act, and they have to mandatory get themselves registered with RERA. So if you have paid any amount to any project or a builder, you can easily claim under section 31. And what you have heard that they are saying out of the jurisdiction of RERA, it is incorrect. RERA is given, there are a lot of cases we have fought, and even there are so many cases in Bombay High Court as well. They have held that promoter cannot go away or run away from their duty, which is prescribed under the RERA.
You may refer to the judgment of the Bombay High Court in 𝗤𝗏𝗏 Corporation, where the Bombay High Court has very specifically stated that this law is retroactive law. So all the agreements which have been entered before the establishment of this implementation of this act, all are covered under the RERA law. And if the project has not been registered, still they will be covered under RERA Act, and you can actually go for refund.
So now I can see one more question. Can a criminal complaint be filed against the builder of a project is unregistered and not giving any refund? So there are 2 things. If a project is unregistered, you can go and file a simple application to the RERA authority that this project is unregistered and they are taking money from the public. So far as criminal law is concerned, then you have to see whether any of his actions falls under the various crime which is mentioned as the IPC or not. and then you can, if some case is made out, then you can go and lodge a FIR also. So and as I've said that both have exclusive jurisdiction. There is no overlapping wherever it is comes to a criminal law, be it SARFAESI, be it insolvency, be it any other law. Magistrate has the only power to adjudicate and decide the matter.
Do we have more questions?
Yes, actually, under residential lease agreements, A, who is liable to pay any charges and on what basis? B, what is the implication on backdated draft lease agreement dated 2018 on stamp duty and registration payable in 2020?
Sorry,
I'm not still
can
clear
you-
with the question as such, Matlab. Can you just simplify it?
Under residential lease agreements, who is liable to pay any charges and on what basis?
See, when it comes to residential leases, it depends upon the norms of the society, whatever, as in the particular state, whatever the lease cost is. But again, the question being that are we referring to the society or the builder? Now, this is with regard to the state, like as we are speaking of Maharashtra, Maharashtra charges a different amount when it comes to lease on stamp and registration.
It's again different. So
Right.
So hello.
Yes, yes.
So I'm not still very much clear as to when it comes to the builder, how we are fixing a liability over the builder here. As in, this is with regard to the cost charge upon the on the basis of maintenance of a society. So that's upon the society to decide, not the builder.
Right, right. I think this is something from the secondary market, not fresh. See.
That's a different question.
All right, all right. We can
So-
move on to the next question.
Yeah. So one more thing I would like to add, that RERA is not limited to the fresh allottees. Even if any allottee who has subsequently acquired the interest in that property, he will be also entitled to claim refund and all these things from the promoter.
Well, also,
His right is also protected.
well, I also recollect one of the judgment where it was stated that when it comes to maintenance under a stipulated project, a builder could not charge like anything. He has to mention that whatever charges are put through when it comes to a particular society, the maintenance, the clubhouses and everything. So if your question is with regard to the same, yes, the answer is that the builder could not charge you like anything. He has to put a module in front of you that this will be your charges, and it should be in prospects to that particular project only.
Right, right. Next question is, under tripartite agreement, promoter play role only as developer, whether promoter can sell, dispose of car parking in open stilt area under RERA. So I guess the question is if the promoter can sell or dispose of car parking in open stilt area under RERA.
See, the question being, when it comes to this is a question with regard to the Registration and Stamps Act. Now, when it comes to stilt parking, parking could only be sold to a lottee if a registered deed has been entered. If you're just making a booking and just giving on paper that particular parking is now belongs to you, it's not actually true. Because for that, you need to enter a registered sale deed with regard to that particular car parking. So basically, the person, the concerned allottee will have extensive right over that particular property. So yes, it is, but I don't think so the concerned law allows to do so, because reason being that this is a common area and a common area belongs to the society. So the question being that if the builder has been provided a right to sell, they need to sell it through a concerned sale deed only.
Right. All right. So we can move to the next question. Can a criminal complaint be filed against the builder of the project if the project is unregistered and the builder is not giving any refund?
No, sir. I think that question I have answered already.
All right.
Yeah.
I don't think we don't have any specific questions. So
Yeah.
Right. So I think we can conclude this session for today.
Yeah.
Great.
So thank you, Akshay, and thank you, LawSikho, for organizing this webinar, and thank you all the participants who have a very awesome audience here.
Right, right.
Yeah,
So I can still see people having questions, but I'm really sorry we have overshot the time already. You can check out our course. We cover all these questions in real details, and we have online classes like this for our students as well. So you can check that out. I have given the link. To end this, I would really like to thank both of you, sirs. It was a real pleasure to share our platform with you, and I'm really looking forward to have you more again. So thank you so much for taking out your time. Thank you so much, everyone, for joining this session.
thank you,
Thank you,
Akshay.
Akshay. Thank you.